The facts matter.
Good morning, everyone. Virgo here. It is the 12th of October, and I have been doing some research along with a subscriber of mine by the name of Dave H., who has always provided awesome information that he has located also, who knew that I was trying to locate information regarding Mitchell Timothy Taebel. Now, as you guys probably remember, I did a video of Mitchell last week and showed you guys that he has a YouTube channel that's up, but I didn't know what had actually happened or how he had found himself out of jail. Well, this document will give us some information with regards to what has occurred, at least the latest that we can find on record. So here we go. This is State of Arizona versus Mitchell Timothy Taebel. This is, I believe, from April. Let's take a look here and see. Let's see. Okay, as you can see, this is evidentiary hearing regarding restoration to competency. Yes, this was from April 9th of 2021. Court reporter, let's see, Okay, here we go. The reporter and any other testimony and evidence submitted have been considered. The court finds the defendant is unable to understand the nature of the proceedings and or is unable to assist counsel in defense and is therefore criminally incompetent pursuant to ARS section 134517. The court further finds that there is no substantial probability that the defendant will be restored to competency within 21 months after the date of the original finding of incompetency, based upon the written report of the experts and the fact that the defendant has been in jail for over 3 years and been in restoration 13 months. The court further finds that restoration is not feasible in the time frame, and that if restored to competency, the competency would likely not last throughout the pendency of these proceedings. The court further finds that there is reasonable cause to believe that the defendant is a danger to himself, a danger to others, persistently or acutely disabled, or gravely disabled as a result of a disorder pursuant to ARS section 36501. The court further finds the defendant is unwilling and is not capable of voluntarily consenting to admission to a mental health treatment agency for the evaluation, care, or treatment of her medical or mental condition. The court further finds that the defendant is likely, without immediate or continued hospitalization, to suffer serious physical harm or serious illness, or to inflict serious physical harm on another person prior to evaluation and further hearing. It is ordered that the defendant shall be immediately taken into custody by the sheriff and shall be immediately transported not later than 14 days from this date to the Valley Wise Behavioral Health Center for inpatient evaluation pursuant to ARS 36530. Nothing in this order shall prevent an interested person from filing an application for evaluation of the defendant at any time or prevent the defendant from voluntarily filing an application for voluntary admission to a mental health treatment agency. Nothing in this order shall change or limit the duties and responsibilities of the medical director of the mental health treatment agency pursuant to ARS section 36501. It is further ordered that the original reports of the mental health experts shall be sealed and maintained in a confidential manner by the clerk of the Superior Court. Said reports are not to be disclosed to anyone except as provided for in ARS 36509. So as you can see from that statement right there, from that order, it appears as though we were not to be given any updates as the public. And as a result, everything pertaining to the mental health orders and treatment was to be maintained in a confidential manner. So we would have absolutely no idea whether or not they chose to release him after a certain amount of time, because it was ordered for the public not to be updated. It is further ordered that the county attorney is to file a petition for court-ordered evaluation with the clerk of court pursuant to ARS Section 36521F by 5 p.m. on April 13th, 2021, and provide a copy of the filed petition to this division. The division staff is directed to review the file to determine compliance within 48 hours of the petition's file date. It is further ordered that counsel for the state in this cause furnish to the probate registrar copies of all police reports concerning the charges in this cause by 5 p.m. April 14th, 2021. The copies will be sent to the evaluation agency to aid in the evaluation and treatment of the defendant. It is ordered that a guardian be appointed to assist in determining whether Title 36 guardianship proceedings should be pursued in this case under Rule 11 and accompanying statutes. It is further ordered that all medical records currently in the possession of Correctional Health Services shall be promptly delivered to Valley Wise Behavioral Health. It is ordered that the defendant shall not possess, purchase, or receive any firearms, ammunition, or other deadly weapons. The Department of Public Safety shall be notified and is entitled to information as detailed in ARS 365400. It is further ordered dismissing without prejudice the criminal charges in this matter, effective upon defendant's admission to Valley Wise Behavioral Health Center. The court notes that it has previously reported that the defendant is not enrolled with Mercy Care. So, there you have it, folks. Sorry, not a good outcome on this, in my personal opinion. I do believe that there's a possibility that a wealthy family member, a wealthy parent even, might have gotten involved in this and somehow worked some things out. But it appears as though this case was dismissed without prejudice. Based on the fact that he was going to be admitted into a mental health facility, which apparently has released him. Or that is as it appears. All right, everyone. I hope that answers your questions. And I hope everybody has a great day. Bye-bye.